Good afternoon, everyone. My name is Sue Zago, and I'm the director of the Law Library here at the University of New Hampshire School of Law. On behalf of the Patent and Trademark Resource Center, located in the IP Library, and the University of New Hampshire School of Law, Franklin Pierce Center for Intellectual Property, it is my pleasure to introduce our speaker today, Ms. Mindy Bickel. Ms. Bickel is the Associate Commissioner for Innovative Development at the United States Patent and Trademark Office. The Office for Innovation and Development works with many kinds of inventors, universities, small businesses, and underserved populations to educate them on how to use and secure their intellectual property, particularly in the area of patents. Ms. Bickel earned her undergraduate degree in chemistry from Bryn Mawr and an MA and Master of Philosophy from Columbia University, where she also earned a PhD in biophysical inorganic chemistry. She started at the USPTO as a patent examiner and has since had many important roles within the USPTO, including serving as the Chief of Staff to the Commissioner of Patents. She has had much input on the USPTO's training programs, including managing the Patents Ombudsman's Program, a resource for patent applicants, agents, and attorneys. She also helped design and implement the USPTO Patent Training Academy for training new patent examiners. Throughout her career, Ms. Bickel has received numerous awards, including the Department of Commerce Bronze Medal for Examination and Supervisory Accomplishments, a Silver Medal for Improvements in Customer Service, and the Vice Presidential Hammer Award for work in establishing a new customer outreach program in the biotechnology group. Please join me in welcoming Mindy Bickel.
Thank you so much. This is my first time to New Hampshire. So thank you for the beautiful sunny day and the colors on the leaves, on the trees, and I'm happy to be here. I mentioned when we were talking before I was introduced that my preference is to take questions, particularly with this audience. So I speak a lot to inventor groups in my current role. I have done outreach with IP attorneys, and every once in a while I talk to law students, but that's kind of rare, usually university students or inventors in the broader community. And so I want to make sure that I talk about what you really want to hear about, and therefore it would help me out, actually, if you ask a lot of questions. So I'm going to start by talking to you about some of the things that we do tell our pro se applicants and what pro se applicants have trouble with. And why am I telling you this? Well, one of the things that we find we like to do and perhaps is useful to attorneys is to talk about resources that we have that can help an applicant. So at some point, if you become an IP attorney, everyone in here just thinks IP is the best kind of law, right? Right? Yeah. So if you become an IP attorney, you may have some experience that we hear from IP attorneys that work with small inventors. They really do not understand the process. How many of you feel like you understand the process right now? Okay, awesome. Well, I'm going to call on you guys then. It's a pretty confusing process to somebody who doesn't have any legal background and training. It's, we also, of course, register trademarks. The trademark process, there are good reasons to hire a professional to help you with trademarks. But on the patent side, trademarks, you probably could navigate that yourself or an inventor could. On the patent side, it's pretty complex unless you have a very simple, straightforward invention. And we're doing a lot of work right now to try to help increase the success rate of pro se applicants. And so here, as it says, first thing is a lot of inventors have no idea what a patent is or what it gives them. And we spend a lot of time explaining, first of all, you are not given the right to practice your invention, and they have a hard time with that one. And then once they understand that you've got this exclusionary right they don't really understand quite what that means either and why they should get patent protection. So that's a big deal to them. And then provisional versus non-provisional. So we have a lot of applicants contact us to say, in my office, to say, I filed my provisional application, when will it be examined? I want my patent. And of course, it's not examined ever, the provisional application. It gives a filing date and so forth. And again, as I said, it's a pretty complex process. And so a lot of pro se applicants really don't have the knowledge to even start to prepare their applications. There are some pro se applicants that actually have filed so many applications successfully that they're as skilled as a really good patent agent or patent attorney, and they do know what they're doing, but that's kind of few and far between. Prior art, that's a big deal. It's hard to find the best art when you know how to search effectively. If you don't know how to search effectively, that can be a really daunting task. And of course, it's a very, the process is very legalistic. We use a lot of very specific terminology, and we use words in a way that the general public doesn't. I will say I remember in 1989 when I started in the office and I had my 2 weeks, that's all we gave back then, 2 weeks worth of our patent examiner initial training, and we learned about obviousness. And then I was the most obnoxious person to anybody who said obvious to me. I had to explain to them that it had a very specific meaning in patents, not in the real world, but you know, once you start thinking like a patent examiner, it's really hard to turn that back off. A really big deal with pro se applicants is that they just don't respond, or they don't respond timely, and then they run into additional fees. You all know we're fee funded. Does everybody know we're fee funded? So we do not take tax dollars. We take fees from taxpayers. Presumably some of the people who file their applications are taxpayers, not everyone, as people file from foreign countries. But all of our fees are from users of the system, and therefore everything that we do has a fee associated. And so if you do not file timely, you as an inventor don't file timely, and but want to continue with your application, you have to pay more money. Well, if you're a pro se applicant, that can be you know, the difference between you being able to see your application through to its hopefully successful conclusion and you not being able to do that. And asking for help is a big deal. I will say that's a big deal also with particularly new attorneys asking for help. You can ask for help.
What's pro se?
Pro se means by himself. So it's an applicant who is filed without the assistance of an attorney or agent, patent attorney or patent agent. So you can become, I don't know whether you know this, but you can be registered to practice before our office without having a law degree. So you could be a patent agent who just learns enough about the patent application process that you can represent someone without being a lawyer. You can, of course, represent that inventor. If the application goes to court, you would have to be an attorney to actually represent someone there, but you can represent someone before our office. You also, when you graduate from law school and you pass whatever bar exam you want to pass, you actually can't practice before our office unless you take our patent bar. So it's the same patent bar that a patent agent would take, and they have the same requirement for a technical degree that a patent attorney would have. Thank you for asking the question. Other questions? Yeah?
It's true, you mentioned that fees support the patent office, but wasn't there an issue which you actually had a surplus of fees and the government was taking them to do other things?
So we started that's a great question. We started as a fee-funded agency in 1993 or two, something like that. I was not yet even a primary examiner at that point. the thinking was, I think Food and Drug also is is to some extent fee funded, and the thinking in the federal government-wide was that, you know, why should taxpayers be paying these fees for a service that someone in particular is getting? So we became a fee-funded agency. And in the 1990s, which as is true now, we take in the money, we have to still give a budget. Our budget goes through the process in Congress, and our money is still appropriated back to us. So it's not like the money comes into us, we keep all of it regardless, and Congress gets nothing to say about it. Congress, in fact, does have something to say about it. And in the 1990s, what they had to say was, you can have this much of your fees, and we're going to use the rest of your fees for something else. And I think actually it might have been the other way. It might have been, we are taking this much, and let's hope you take in the rest that we've appropriated back to you to use. And I don't remember what the percentage was. And I have no comment about whether that was, you know, the right thing to do or not. That was just what was done. Sometime, I believe, during the Bush administration, there was a push, during either the first or the second, there was a push to give us full access to all of our fees. And that came primarily from the inventor community, from the IP bar, saying, hey, we're paying for a service. And, you know, the patent office has this huge backlog that they have because they can't hire enough patent examiners because there's diversion of their fees to these other agencies and programs, and again, those are all of those programs are worthwhile and equally deserving of funding. But the point was, you know, is this taxation without representation, as some people were complaining? So there was a push to give us full access to our fees, and we now do have full access to our fees, and in fact, even better, right now we have fee setting authority. So what we can do is look at our process and say, this is really how much we think this piece of the process costs, and that's what we're going to charge. That's the fee that we will charge, and that gives us the ability to you know, update our IT systems and make sure the examiners have the best search tools so that they really can do the quality examination that we want them to do. And that fee setting authority expires next year, I believe. And so Undersecretary Lee just testified before the Hill last week and did note that to Congress, that that fee setting authority is going to expire. And what that allows us to do, again, is to look and say, okay, now this has become more expensive and we need to raise the fee because, you know, we're not getting enough revenue in. And it also helps us deal with the you know, the up and down of filings. So we're pretty good at forecasting what our filing rates are going to do. And this fiscal year, which ends September 30th, which I think is a week from Friday, maybe, we forecast a 1% increase in our filings, and I believe we're on track for a 5% increase. And I haven't looked at numbers probably since the early summer, so that might not be correct. But, you know, we never know. Are we going to under forecast? And so if our filings increase, of course, that means we're getting more revenue in, and that's a good thing in terms of us being able to hire and update IT systems and all that kind of thing. If we have fewer applications coming in, if we forecast too high, we have lower funding coming in, and then again, it makes it hard to hire and so forth. Also, with our fee setting authority, we were given the ability to create a, I think we call it an operating surplus, and that has great advantages to us. Again, remember, if we aren't working, if the patent examiners aren't working, they are not examining patent applications, and it's not like they can catch up because they're on a production system. Do you guys know that examiners are on a production system? Okay, so if there's a government shutdown, happens every once in a while. I believe that I heard that Congress has said they are not going to shut the government down this October 1st, but I haven't seen that officially. I think I just heard it on the news. If the government does shut down, because we have this operating surplus, we can actually continue to work. Our folks are expected to come to work. We can continue to operate as long as we have that operating surplus that allows us to pay employees. It's finite, so if the government was shut down for too long, at some point we would have to say to the employees, okay, you can't come anymore. But it's really important to us, as Congressman Issa actually pointed out at the hearing last week. We can't make up the work if the patent examiners don't work. If we close, they come back and we can't say, hey, so that 2 weeks that we were closed, you guys need to do extra patent applications now. No, they're on a production system and they pick up where they sort of left off and they start going. And that slice of time is never made up, and our backlog was increasing. So there were applications not being examined and applications continuing to come in, not being processed, but continuing to come in. So that was a very long answer to what might have been a sort of simple question, but did I give you what you wanted? Okay, thanks. Okay, so patent application protection. Do you all know about the exclusionary right and Article 1, Section 8, Clause 8 of the Constitution and all that? Been through all of that? No? Well, so I need to have it in front of me. I never remember how to recite it. Who can recite? Anybody? Article 1, Section 8, Clause 8. Congress has the power to promote progress of science and the useful arts by giving to inventors and authors. Who's got it? Anybody? Exclusionary right for a limited period of time, or the exclusive right, limited time. Can't remember the whole thing. But there you have it. So it's the right to exclude others. So I mentioned earlier, something that pro se applicants really don't understand is that what they're given in a patent grant is the right to exclude others from making, using, selling, or importing their invention. They're not given the right to practice their invention. And why is that? Well, you can imagine a circumstance in which you have invented something that is an improvement over someone else's invention. And if that someone else's invention is the subject of a patent that's still in force, the government can't tell you have the right to practice your invention. You would be infringing on that other patent that is still in force. So the government doesn't do that. It says instead, you have the right to exclude others. So the first patent has the right to exclude others. You have the right to exclude others. Somebody invents a chair, very simple example, and somebody else comes along and puts wheels on the legs on the chair. Wheels are an improvement. Neither of them can practice the entire thing, so the first chair patent can't put wheels on it. They'd be infringing on the second one. And the second patent can't actually make you sell or import the chair. It's got the wheels. And, practical matter, people cross-license and that kind of thing. But it's a really important distinction, particularly for the inventor. And they tend to be sort of puzzled about why that is. But I think it makes sense when you think about the fact that your invention could be the improvement on somebody else's. The other thing that that Article 1, Section 8, Clause 8 says is that your protection is for a limited time. So it's not forever. It's for a limited time. Right now, the patent term is 20 years from the date of filing. So the faster you get your examination through the patent office, the more time you have to enjoy your patent rights. So you can't enforce your patent until it's actually granted. So if you have one of those applications that takes 3 or 4 years, if it takes 4 years, you have a 16-year term. If it takes 1 or 2 years, you have a much longer term. And so there's a lot of pressure on the patent office to get applications out the door quickly. When Director Capos started, I think he started in 2009 as the head of our agency, he charged the office with getting to 10-month first action pendency. I I actually don't remember where we are right now. I think it's either 14 or 16 months. So we've gotten much closer. We had periods in the early 2000s, 2005, 2006 maybe, where in some instances we had 4 years to first action. What does that mean? That time to first action means the time period from the date of filing until the examiner picks up that application for the first substantive review. So before that time, it might go through pre-examination to look for formal matters and make sure that all of those are in compliance. But first action pendency, as we call it, means the point at which the examiner picks it up for the first substantive review and lets the inventor know whether they've complied with the statutes around novelty, non-obviousness, clarity, enablement, and patentable subject matter. Something else that pro se applicants can be confused about is that there is no worldwide protection. So a United States patent is valid where? Any guesses? United States and its territories, right? So it's not, you can't take your patent to another country, the US patent, and say, hey, you have to stop doing this in France. I'll pick on France for the moment. It's not enforceable there. It's a United States patent. And there is no worldwide patent. There are some things that you can do that sort of make it easier, kind of gateway application, PCT application. And we have made efforts to harmonize, most recently with the America Invents Act in 2011, that changed us from a first to invent system to a first inventor to file system, among other things, among other changes that it made. That was an effort to have our laws harmonized with the rest of the world, which has the effect of making it easier for an applicant to file in other countries. We also have, I don't think I have a slide on it, but we have something called our Global Dossier system, I think we call it. And that's a portal that allows management of applications that are filed all around the world, including the United States. It's useful to patent examiners because they can go into Global Dossier and see whether that application has already been examined in another country, and they can take advantage of any prior art that another examiner from around the world has cited against the application. Questions?
Percentage pro se applicants make up of the total patent pool that you see?
It's actually very small. I don't know the percentage right now. That's a great question, though. I'm going to have to find that out. One thing that I can tell you that's sort of a shocking statistic about pro ses and why we're giving them a lot of attention right now, 40% of applications filed by pro se applicants do not make it out of pre-exam. So that's a lot of innovation and possible job creation, possible improvements to our standard of living, our quality of life, cure for cancer, that aren't even getting to an examiner to get a read on, do you have a patentable invention or not? They don't make it past the formal matter review. So we're doing a lot to try to turn that around. We have sort of a double-edged, I don't want to say sword because it's a very positive double-edged program. We have in my office the Pro Se Assistance Program, and then in the examining corps we have a Pro Se Examining Unit. So I'll start with the examining unit. They only look at applications that are filed by pro se inventors. Now, you can't opt in, so if you're a pro se inventor, you can't say, hey, I want my application to go to that unit, number one. And number two, they're mostly working off the backlog of applications that have already been filed pro se. And they get extra time. There's a lot of hand-holding. Have you all had any contact with any independent inventors, we'll call them? Thank you for asking pro se, but we call them independent inventors too. So they're very, very passionate about their invention. So it's, in some ways, it's like dealing with a brand new first-time parent who thinks their baby is cuter, smarter, and better than any baby that's ever been born before. And you can't tell them otherwise. And that's great. They're passionate and they're advocates for themselves. And they don't understand the system. So it can make them a very challenging demographic at times. Challenging maybe is not the right word, but it sort of can take a lot of time. And to that point, in my office, we have the Pro Se Assistance Program. And what we do, we take email, phone call, and walk-in. So you can actually walk into our office and sit down with either a supervisory patent examiner or a patent examiner from that Pro Se art unit, and we'll go through your application with you and make sure it complies with those formal matters. We can't give you a take on whether or not it's a patentable invention. The only person at the Patent and Trademark Office who can tell you whether you have a patentable invention is the patent examiner who's assigned to your case. So no one else, no other patent examiner is authorized to tell you whether you have something that is a patentable invention. So we cannot do that, but we can look through the entire application, we can make sure that you've complied with formal matters, and we will spend 1, 2, 3, sometimes 4 hours with a pro se applicant going through everything to make sure that they really understand what this process is all about. So it can be, it's a small percentage that can take a lot of resources because of the complexity of the system and the lack of knowledge about it.
Why not encourage them to seek advice from the patent agent?
So people are not required to hire a professional, right? We usually tell them that we don't recommend they go it alone. When I was chief of staff to the Commissioner for Patents, and he would travel and he would talk about this issue, he would say, he's had a bunch of root canals. He totally gets the theory behind the root canals, and sometimes you really want a professional doing it for you instead of doing it yourself. I also tell people, when I retire from the office, if I have the next great idea for an invention and I want to file a patent application, I'll probably hire somebody, and I know the system really well. But it's a very complicated system, and I think it is one where people can benefit. That said, there are a lot of inventors that are under-resourced, and they can't. So our fees, are sort of a small piece of the pie for them financially when people talk about, well, how much does it cost to get a patent? And they throw out $5,000 to $20,000. Most of that money is for the IP professional. It's not for our fees. And especially if you're an under-resourced inventor, based on the AIA legislation in 2011, you could qualify for the micro-entity status for our fees, which is a 75% reduction. Now, we do encourage them to get professional assistance with their application. And we now also, because of AIA and a White House initiative, we have a patent pro bono program that's active in all 50 states. So there's coverage everywhere, and if people meet certain requirements, there's an income ceiling that you have to be under. You have to have knowledge of the patent system, which you can do by taking or watching a video online and then getting a certificate for having demonstrated that you understand. And you also have to have possession of an invention. You can't just have a good idea. And if you qualify, you can apply for patent pro bono help, where you get typically a seasoned patent attorney. Now, we have more applicants right now for patent pro bono than we do volunteer attorneys. Where we go out and talk about patent pro bono every place we can where there are attorneys, and encourage people to volunteer because, as you said, we'd like people to be able to have assistance, and for some people it's really simply out of reach. There's also law school clinics. Is there a law school clinic at here. So, I mean, that's another thing that another suggestion that we make to applicants, try a law school clinic. There's advantages and disadvantages to both. I think for some law school clinics, the requirements might be a little less stringent. So if you don't qualify for patent pro bono, you might qualify for a law school clinic. And those, of course, are under the auspices of a professor who is registered to practice before the office, and so they take responsibility and guide. But good question. Uh-huh.
Is there a difference between first inventor to file and just first to file?
So I emphasize first inventor to file. It should be the same thing, but particularly when we talk to inventors, we emphasize that it's first inventor to file, because a lot of inventors are fearful that someone might hear something that they say or see something, because they have a 1-year grace period, right? They don't have to file a provisional. They have a 1-year grace period from talking about it till they have to file. In this country, not so in other countries. But a lot of people are paranoid that, or maybe paranoid's too strong, but fearful that someone's going to hear their idea and then file it themselves. And so what we try to emphasize is that the intention is that it's the first inventor to file. It's not just the first whoever. They heard about it and now they're filing an application. We aren't far enough into it to have had any examples of really interesting cases of someone did something other than what the intention is. I think the transition point for that was March of 2013 was when everything transitioned to now it's first inventor to file. I think that was the date. So we'll probably see. People are very creative, and any rule that there is, people think of some interesting thing to do to kind of test it and see if they can get around it. So we'll see what happens with that. Good question. Other questions? I think this is fairly self-explanatory. Why get a patent? There's so many reasons that it's helpful to somebody who's really looking to start a business. And I will use as an example one of the first patent applications that made it through the system with the first patent pro bono program. That was in Minnesota. And I can't remember the man's name, but his invention is called the Cheetah, and it's a system to help you hang a door. I don't know how to do that, so I'm not going to go any farther into the description of the invention, but apparently it's kind of revolutionary, a big deal. And he got his patent through the patent pro bono system program, and then he got a 6-figure licensing agreement. I can't remember the name of the company that licensed his invention, and but it was a pretty big deal for him to get that. And he's got 2 more ideas, actually, and he's now gone back and he's hired that attorney who did his first application pro bono, and he's paying full freight for his next 2 ideas because, of course, he got the 6-figure licensing agreement. And that's the way that we hope the system will work. So somebody's got a good idea, can't afford to hire an attorney, but it really is a good idea, and it's something that really could make a difference. He's also hired staff. Again, that's part of what we look to the patent system to be an economic driver. So we want people to be able to commercialize their inventions through the patent system and be able to hire other people, make a difference in the economy, and push things forward. Anyway, I think that answers why get a patent. Anybody who's seen Shark Tank? Anybody watch Shark Tank? So Lori Grenier spoke at one of our very first, actually, Women's Entrepreneurship Symposium, and she spent a lot of time talking about what a difference that the patent system made for her. She has over 100 patents, and she talked about her very first patent, which was, I can't remember if it was design or utility or both, but it was for a jewelry organizer that she invented sitting at her kitchen table because she wasn't able to organize her own jewelry in something that worked for her, that she could buy on the market. And so she designed something that she felt did work for her and then took it to a patent attorney. And she's been working with that patent attorney ever since. And when she started, she didn't have a $500 million enterprise. She was just kind of like the rest of us and just had a great idea. And again, now she has a lot of people working for her, and she's nurturing a lot of other businesses, and that is what our hope is for the patent system. I think we probably covered that. Provisional versus non-provisional. Again, this is something that a lot of applicants really get confused about. So the provisional, it's not examined. It's really a placeholder. It's what gives you the, hey, you've got 1 year now. You've got a filing date. Remember, we're first inventor to file, so the race to the patent office matters at this point in time. It didn't used to when I first started. We had an interference proceedings where we would just, before we issued a patent, we would look to see whether there was another application that had claims that were similar. We'd actually go to a file room where there were photocopied pages of claims in a box, and we'd flip through the box and see if there was anything similar to what we were looking at. And if there was, and it was filed within about 6 months of the filing date of our application, we would set up this interference proceeding, which was a pretty expensive proceeding. And the judges at the used to be the what did we used to call the board? Patent and Appeal Board, I think. Board of Patent Appeals and Interferences. Thank you so much. Yeah, boy, wow. All I can think of is PTAB now. The Board of Patent Appeals and Interferences, and they would sort it out. So they would have some judges who would sit down and really look at all the evidence. And that was one of the things that the independent inventor community was concerned about when we were making the transition or the legislation, AIA, was pending, that they would lose out because corporations theoretically had deeper pockets and could file more. So an independent inventor, the argument went, really needs to wait until they're sure they have something that they want to pursue, because even a couple $1,000s to an independent inventor can be expensive. To a corporation, no big deal. If they think they've got anything, they could just go ahead and file. Well, we did a study of interference proceedings, and I think we found that maybe 3 times over thousands and thousands of cases, the independent inventor might have been disadvantaged if there wasn't an interference proceeding, if it was just first inventor to file. And so that was what sort of helped push the Congress to go ahead and go in that direction. Provisionals are only for utility patents, right? So there's 3 kinds of patents. There's utility design. Who knows what the third is? Plant, right? Plant is a very narrow area in the office, so I think there's maybe just a handful of examiners who examine plants. There's one or 2 art units that do designs, and then all 8,000 other patent examiners do utility applications. So that's the bulk of our business, and that's typically what we talk about when we talk about patent applications. Again, it's a low-cost way to sort of establish your earliest effective filing date. You get the benefit of that date. So when you file your provisional, that is your filing date. You get a year to decide whether you want to pursue your non-provisional. So you can use that year to see if you can get venture capital. You can do some market research. There's a lot of things that you can do. And then decide to file your non-provisional, which is what would be examined. And the patent examiner really probably never looks at your provisional application unless there's a question that something was added to your non-provisional, some subject matter that wasn't in the provisional, and there's an intervening reference. That might be the only time an examiner might look at it. Non-provisionals are published at 18 months. Unless there's a request for non-publication, and you have to certify that you're not going to foreign file if you ask us not to publish. This is a really big deal. That started with the American Inventors Protection Act in 1998, 99? Can't remember, somewhere around there. And that was because there were some patent applications or patents that issued that we would refer to as submarines. So these applications were pending for a long period of time in the office, decades in some cases, and industries might have grown up in those technologies because people had no idea before publication what was pending before the office. And then up the submarine would come, and it really caused some chaos in the marketplace. And Congress wanted to give some assurance to people that if they're going to invest in certain technologies and building businesses in certain technologies, that in fact there was some certainty that, you know, nothing is going to pop up that's going to really cause them a lot of trouble. We still have some cases that were filed from before this time period, and and Congress has become kind of interested in those because they're, again, cases that are not open to the public. When I first started in the office, nothing that we did was open to the public until the application issued as a patent. And then all of a sudden the entire thing was open to the public. And now after publication, it's all open to the public. You can go online, and of course you can look and see all of the examiner's actions, the applicant's responses, everything is open. But back then it wasn't open, and we've still got some cases that fall into that category. So it's kind of an interesting time. And the non-provisional, of course, is what could become a patent if it's found to comply with all the statutes and rules. So these are the formal, some of the formal matters, parts, forms, and content. They're not, it's not so interesting, I don't think, to talk about unless anybody has particular questions, because it's just pretty cut and dried. This is what you got to have in there. And then there's, you know, certain other formal matters. But does anybody have a question in particular about that? Yes, sir.
On the provisional, the date of provisional, the filing for date of provisional patent, does that count towards?
I can't really quite hear you.
The filing, the patent filing date for provisional application, does that count towards 20 years?
So your 20 years would start from the date of filing of your non-provisional. Yep, thanks for that question. Again, claims, right? Claims, we love claims. Claims are what it's all about in the application. Everything else is great, and it has to be there. But, you know, the claims are really, it's an art form. And I think, this is just my personal opinion, that's not the position of the office. I think what you're paying a patent professional for is this piece. The rest of it, you know, I was a scientist, you can kind of write all that other stuff up. But the claims, writing the claims is really kind of tough. And this pyramid sort of suggests why, or the triangle. If you get too specific, which is up at the top, you could easily get a patent. Easy. You make your claims really specific, that patent examiner is gonna, what we used to say back in the day, slap a blue slip on your file, because we actually took blue slips and attached them. We don't do that anymore, it's all electronic. And out the door it will go. And congratulations to you. And you won't probably have anything that'll help you further your goals if you're trying to start a business, because it's so specific that somebody could easily invent around it. If you're too general, you make it really easy for the patent examiner to say you're not entitled to a patent, right? Because, you know, the patent statutes say you are entitled to a patent unless. So the burden is on the patent examiner to show why you're not entitled to a patent. And if you give the patent examiner really general claims, easy for them to find prior art references that will render your application unpatentable. You have to get somewhere in between those two. There's a sweet spot that's not too broad and not too specific. And typically, a patent attorney, anyway, will come in with some really broad, I guess I should go like this, coming up from the bottom. Let's come with some really broad claims, some that are a little more narrow and some that are seemingly a little bit specific. And the part of the reason, again, I'm projecting, but part of the reason I think they come in with some of the broad ones is so that they have some room to work with the patent examiner to get a little bit more specific as necessary. You don't want to come in with just specific, because you might not have anywhere to go to get more broad. And so it's an art, it's a back and forth, and that's where the interaction with the patent examiner can be really helpful, and we encourage that because, as I said, I think it's this part when you're paying for a professional, I think it's this part that the professional becomes really helpful. So what does the patent examiner do anyway? People are always kind of curious about that. I was a patent examiner. You pick up the application, and the first thing you have to do is really read the specification. That's where the specification is helpful. You might look at the claims first, read the claims, and then go back and read the specification, or you might start with the specification. But the specification is going to be what helps you understand what the claimed invention is. And as you know, you probably know, it's really easy to miss what somebody's really talking about when you've got just the written word. It can be really easy to misunderstand. I do remember, I think it was back in early 1990 when I was still pretty junior examiner, I had an application. I knew what they were claiming. I had good art, and I sent out a rejection. I totally understood that invention, totally, until the attorney called me and said, I'm not sure you understand our invention. This is what our invention is. Didn't understand the invention. But from the written word, I thought I did. My interpretation seemed, very reasonable and right on. So I think very important to remember that it's easy to miss each other in the written word. So we read and understand the invention, and then we start looking to make sure that the application is in compliance with all the applicable rules. That changed, like we did with AIA. We had, as I said, I think it was signed September 17th maybe, or 16th of 2011, and we had till March of 2013 to implement Firstinventortofile. So we had a long period of time, and we could engage with our stakeholder community and talk about how we were planning to implement and train all 8,000 plus examiners and et cetera, et cetera. And when a court decision is handed down, we don't have that lag time. And but you're right, things change all the time, and I think that's one of the things that makes the job of a patent examiner interesting. Is you're constantly, okay, now we have a new thing that we have to consider and think about. So this is a sample office action. Have you ever seen one? It's our summary sheet. It's not really the office action, right? So back in the day when, right before I first started, this is pretty much all an applicant would get. We would just say it's obvious or it's not novel or whatever it is that we would say. And then we started looking at compact prosecution and making efforts to make the process much more understandable to the inventor. And so this is the summary sheet. Behind that summary sheet, there could be pages and pages and pages of explanation as to why we find this application not patentable, and also suggestions for what the applicant can do to overcome the rejections. And then it's time for the examiner for the applicant to take a turn and respond to the official action and to say, the applicant has a lot of options. So the applicant can just argue that our logic is incorrect, we have misread the invention, we have misinterpreted the reference, that what we say is shown in the reference isn't shown. The applicant can amend the application to overcome any rejections, and the applicant sometimes abandons. And from what we're hearing, our quality efforts have actually helped some attorneys who are in-house make decisions to, okay, we're going to abandon this one because it really looks like it's not going to move forward. So all of that is after a non-final office action. After we've gone one round, we can have a final rejection, and at that point, what the applicant gets to do after final is a little bit more limited. So there's no right of entry of an amendment. They can still argue. And examiners do have to respond to all arguments and explain everything that he or she does with the application. I talked about this with the question about percentage of applications that are issued after first action. we can't emphasize enough the importance of interviews. We really encourage people to contact their examiner. Now, if somebody is represented by an attorney, they can't contact us themselves. They can't call the examiner without their attorney and have a conversation. We don't conduct dual communication, but we really encourage the attorney or agent who represents or the pro se inventor to contact. And they can have interviews, we can have interviews in person, over the phone, or using WebEx. And we actually have a team that is training attorneys one-on-one to use our WebEx tools with us and showing attorneys how to share screen and mark up claims, proposed claims, and all that kind of thing. We talked about fees. Our fees typically do change at the fiscal year point, which the beginning of fiscal year is October 1. So what we try to do with our fee structure is make it a little bit less expensive upfront so people can get into the system and find out at least whether they have something that could be patentable. And then we kind of load up our fees at the other end, thinking that that's where people are either successfully commercializing or have, for some other reason, decided that they still want to maintain their patents. So in other words, if your application is allowed, you have to pay an issue fee. And then I think I have a slide that talks about maintenance fees. Maintenance fees are really important. You have to pay them at 3.5, 7.5, and 11.5, I think, years. And I think they get progressively more expensive. Again, the thinking is if you still want your patent to be in force, you are making money off of it, or you just want it and you're willing to pay. But we try to keep the fees lower up front to get people the ability to get into the system, to find out whether they have something, and then load it up at the other end. So, and there it says, maintenance fees. And that's just the process after the grant. Sometimes there are mistakes that happen and need to be corrected. Minor. They're usually minor spelling of something that's corrected by certificate of correction. So we have lots of resources on our website, tons. That's where you go if you want to apply using EFS Web. You can find out the status of an application using our Palm system. We have a handy tool called the First Office Action Estimator on our website, where you can find out when your application is likely to be picked up for examination. How that works is you need to know the art unit that your application is assigned to, and then you look to see what the average length of time is to first action in that art unit. PAIR gives you details of all currently pending applications that are already published. You can search, get our fees and forms. Pro se and pro bono programs, which I've talked about. We also have an Inventor's Assistance Center, which there's a little typo there. It should be IAC, not AIC, but oh well. See, certificate of correction, I guess, is necessary there, right? And the Patent Ombudsman Program. If you haven't heard of the Patent Ombudsman Program, if you intend to be a practicing IP attorney, you probably want to pay attention to that part. So the Patent Ombudsman Program was established to ensure that the patent application system works the way it's intended. So that's not the place to go if you don't like the system. If you want to complain about how the system is designed, you don't like it, you need to go someplace else. Well, actually, you can go there, but they have no power to help you. But if the application process is not working the way it's intended, the Patent Ombudsman Program is the place to go. So I'm not there anymore, actually, so I need to stop saying we. I helped establish that program in 2009, and the kinds of things that we would see are typically, or they're anomalies, right? They're not the typical process, and so the stories don't tend to be our finest moments at the Patent and Trademark Office. So we might have somebody call and say, I've gotten a 6th action non-final, and I just want to, get it to the board or come to closure. Can you help me? They might just have a status inquiry. We do get pro se's calling, but mostly attorneys. I remember having some attorneys calling asking me how to revive an abandoned case. which I thought, well, don't they teach you guys that? But apparently not. So I taught them how to do that. So it's whatever you might not know how to do. It's not really a teaching tool, but they'll help you. Whatever is not working, you don't know where to call to solve your problem. We either know who can solve that problem for you, or we find out who can solve that problem for you. So I think the Patent Ombudsman program is really an unsung hero. And another tool that we have is called our IP Awareness Assessment Tool. I think it's a terrible name because I don't think it communicates the power of the tool. It's a place where I think it's great for people to start who might not know what they have and in terms of intellectual property. So it's a self-survey. There's either a pre-assessment or a full assessment. And you answer questions based on what you might be using to start a business, for example. And at the end of answering all those questions, the tool will suggest to you that you might want to consider patents and copyrights or trade secret and trademarks. And then it'll send you to other places on our website where you can find out more information about those different types of intellectual property. So I think it's a great tool. It's a great starting place, and maybe not the best name for it. Again, we have so many resources on our inventors and entrepreneurs pages, and we also have a by state page. We have a map of the United States, and you can click on your state and find out what resources, PTRCs, are in your state and where they are. This is our pro bono program, so we're pretty excited about that. First time that patent applicants or inventors have access to pro bono services, and it's a pretty great thing, as we talked about before. I talked about this one already. These are our fees. I tend not to dwell on them because they can change, so it's best to just go to the website. But what is instructive here again is there's the full freight, and then there's a 50% discount for small entity and a 75% discount for micro entity. And these are just some contacts. Patent Ombudsman, like I said, I think that's the unsung hero. So if you end up being somebody who practices, might not stick in your head right now, but try to remember to use that program. And that's the end of the slides. Questions?